we had a client there about 2 years ago. She's arrested for drink driving. In Dublin. She is brought to the station. She has a urinary tract infection, and it's summertime. It's high summer, so she's dehydrated. She's given the choice of blood or urine. She opts for urine. She's afraid of needles. She's in the toilet trying to provide. She can't really provide. She can only provide a small amount. And guards are saying, you need to move on now. You need to you got to provide. Otherwise, you'd be charged with failing or refusing to give a specimen. And that's a 4-year disqualification. Serious. If you fail or refuse to give a specimen, it's a 4-year disqualification. And she's trying, but she can't quite give the appropriate amount. What they do with the urine is it's a kind of a jug, like a Pyrex jug, but it's plastic, and you urinate into that, and it comes up to a certain amount, and they pour it into 2 little glass vials. The doctor does, and they seal it, and they put the stickers, your name and date of birth on the side of them. You're given one to take away. So they're 2 5ml bottles, small little things. 2 5ml bottles. You get to take away one. The other one then is packed into the box and it's sent off to the Medical Bureau of Road Safety. So the guard in that case said, you haven't given enough. You've only given enough for 1, not for 2. So that's not enough. So I'm regarding that as a failure or refusal, and I'm charging you with drink driving, or failing to give a specimen, I should say. And that's what she was charged with. But in court, we put it to the guard that she had given some, yes. How much had she given? He wasn't too sure. He thinks it was about 1, just shy of 1. And we had a witness from the Medical Bureau of Road Safety outside, and they said that we can analyse on 2. Like, the medical science has moved on so much now that we only need 2 mils. We don't even need 5. We certainly don't need 10. We can analyse on 2. So even if she had given 4, you could have split the 4 into 2 vials, 2 and 2. She takes away 2. They have the other 2. And because she had given some, and they just threw it away, and they didn't know how much she'd given, and it could have been 4, the judge had a doubt about it and dismissed it. You're navigating a case through kind of choppy waters. You have to be, if you want to elicit answers, you have to ask questions in a certain way that elicits the answer. Okay, so if you want to get a specific answer, you have to ask a specific question. So questions do matter in court. And so we had worked on that, and the questions that needed to be asked to elicit the answer that we did get were asked. And in fairness to the guard was very, very honest, very straightforward. He had no difficulty with this woman, at all. He gave very fair evidence, and he freely admitted, it's a mistake. But it was a difference between staying on the road or going off for 4 years. And like, if you go off, if you really think about it like I do, that if you're off the road for even a year or 2 years, insurance companies are going to hammer you with an insurance premium the next time around. They will just hammer you. Financially, it's a huge, huge hit. And it's a conviction too. So once you have that to the forefront of your mind, and I do, you know what you kind of have to do. So in my case, it's to fight every case, no matter what.